Welcome to Milltown Lawyers.
Hello and welcome to Milltown Lawyers. I'm James Dutton, and this is my mother, Debra Dutton. Together, we run the law firm of Dutton & Dutton here in Griffin, Georgia, where we fight for justice with integrity. We cover all forms of law here in the Georgia region, criminal defense, bankruptcies, estate planning, small business law. But today we're
personal injury,
all kinds of stuff. Today we're going to focus a bit on what we call life preparation. And now that's Debbie's sort of forte. So tell us where we want to be. Obviously, you don't want to die without a will, but there's more to it than just a will. What else do we need?
So there's so much more to it. I just did a seminar today, actually, at our local library for some senior citizens, talking about what you need to do and what you need to think about as far as getting ready to leave this life. And a lot of us don't like to think about that, but I see an awful lot of issues when things aren't taken care of on this side of the grass, right? And you think things are going to go the way you want it, and then you pass away and you leave your loved ones kind of in a mess. So the first thing I usually tell people is the most important thing to me is leaving love letters. Now, I think love letters should go to your family, because how awesome would it be to have a personalized handwritten letter from your mother or from your grandmother, and it would just talk to you from the grave.
All those things that you couldn't have said in life, or were afraid to say, or held back,
or maybe did say. I think that I always tell people, to me, the thing you should start with is your testimony. I met with this group of seniors today, and I may have been the youngest one there, but we talked about the fact when we were kids, life was so simple and so easy. And for our grandchildren, there's no telling what the world will be like. And they will have dark days. It's not if they'll have dark days, but they will have dark days. And if they had a letter from their grandmother that said, "Hey, I want you to know that I know that Jesus is the Christ, that God lives," maybe put in your favorite scripture verse out there. Just bear your testimony. Maybe tell them your favorite memories with them, favorite trips you've taken with them. Tell them their birth story, where you were the first time you heard them cry, or different things like that you get to say to your grandchildren. Maybe even tell them a little about yourself, because people see me and they see a 65-year-old lady. They don't see a really cool hippie chick in the 70s. So it kind of helps to let them know that you weren't always 65 years old. So I like the idea of love letters, a personal handwritten letter to your loved ones that you'll place with your will, that will be read by that individual after you're gone.
What about videos? Taking a little video. Hey, let me tell you my story. This is me on camera telling you about.
I like that idea as well. And I do plan to go through my house and say, okay, this set of china belonged to my mother, and this set of china was given to me by my sister-in-law. But a letter is just something tangible that they can hold and, keep in their scriptures or keep somewhere close. So I do like the idea of a letter, and maybe you keep a journal or a diary, and maybe that takes care of that. But if you don't, then a personal letter from mom or grandmother, I think, would be something special. I know I would treasure that if I had that from either my mother or my grandmother. So that's usually where I tell people to start. And it's not where most people expect me to say where they should start.
That's not the most lawyerly thing that you expect. Right. That's not the legal advice that you're expecting. But again, this is kind of what makes Dutton & Dutton a little different than most firms. It's not about, hey, let's check these legal boxes. It's about, how do we holistically take care of you as our client and make sure that you're in the right spot. So that's just something indicative that I've noticed. Again, I learned it from you, is how to take care of that person, not just their legal problem, but sort of their whole issue. What other things, not just sort of that personal touch, but are there anything else as far as that personal touch? I mean, before we get into the legalese of it.
Well, the big ticket item, and this really is the legal part of it, but the big ticket item for most of us is our house, our home. And that's usually what's passing through a will. So I do talk about the deeds, but before I get there, I will say that if I die tomorrow, I'm just leaving behind stuff, right? A house, a car, a bank account. If you die tomorrow, you're leaving behind 2 children.
2 little kids.
Okay.
Yeah.
So
a little tougher.
A lot of times people think they have to be my age to do a will. And to me, it's just stuff. Odds of you and your wife dying at the same time are slim to none. You know, I have had, your father had a cousin die in a car wreck, he and his wife, same time. And there was a little bit of a battle over their 6-year-old son. But if that happens and the 2 of you die simultaneously, plane crash, car wreck, whatever it might be, then there's a chance that it would be up to the court to decide who raises your children.
That's not what you want.
And
That's
you don't
not
want
what
a
you
court
want.
raising
Oh,
your
Lord.
children. So I always say to people with young kids, you need a will more than I do.
Yeah.
Let them duke out a house in court, but you don't want someone that doesn't know you deciding who gets your kids. So I do think wills are for everyone. So with that said, the top thing that passes, other than children, through a will is your real estate. And so I challenge people to do a deed checkup. So you want to go to the courthouse, even if you haven't finished paying, even if you have a mortgage, you want to take a look at that deed and see what it says. Now, here's what I mean by that. If your deed says husband and wife joint, you think you're good because I own half, he owns half. But if your husband dies and doesn't have a will and there's children,
right, then his half doesn't just go
right.
you.
That's right, unless there's magic words in that deed. So what happens upon his death, unless there's a will or magic words, I retain my half. In Georgia, you can't get less than 1/3 of his half, but the other 2/3 of his half would go to his children. And, you know, for me, that wasn't a problem. It was our children.
Yeah.
But if there's stepchildren out there, maybe he had kids before you married, or there could be a problem. So the magic words that you want to look for in your deed is joint with right of survivorship. And it's really a whole sentence, but the magic words are survivorship rights. And if your deed is old, it likely doesn't say that because we didn't do that back in Georgia.
Right.
This is kind of something new. We did not do that. And so my deed didn't say that. And it was from 1980. So
is there tax implications as far as it going to the kids as opposed to you? Or if it goes to you, since you've already owned it, is there... Maybe that's a bigger, maybe we do a whole podcast.
There may be a whole podcast on that where we bring in your wife, who's the CPA,
yes,
right?
Yes,
She's
certainly going to come in
those
and be a guest
us
at some point. But
and so that is a very good question, but I think that would take too long to go into that. That it would be a question that you would ask when you are doing your deed. But if the deed says joint with right of survivorship and husband dies, the whole property then belongs to the wife. And I see an awful lot of that. I see an awful lot of sweet little widows who were not prepared for their husband's death. And then there's stepchildren, there's adopted children, there's mine, there's yours, there's ours.
Or an estranged child that's going to be kind of a jerk about it.
Yes, that one we had.
Don't want to mention, but
So there can be issues. So the first place I tell people to start is with your deed. Do a deed checkup. I take a look at deeds for free. You just email them to me and I tell you, do we need to change the deed? Or I had a widow there today. She brought her deed with her and I went, fantastic. It's a right of survivorship. And she said, well, now what do I do? Well, now we only have to change the deed. You don't have to probate. So that was good news to her. So she's coming in next week and we're going to redo this deed, take her husband's name off and put it in just her name.
You mentioned a word just now, probate. Now, this is sort of a term of art that makes sense to us lawyers, but go into what that means, and are there costs involved in probate, and what does that mean?
So if you're not set up for everything to pass outside of probate, then you're going to end up in probate. So joint with right of survivorship would prevent the real estate, the house, from having to be probated.
And probate means going before the probate
judge.
Going
before the probate judge.
A whole hearing and a whole thing, right?
Well, it's not really a hearing, but there's paperwork 16, 17 pages long. Everyone has to sign off on it. The stepchildren, the adopted children, the estranged children, everyone has to sign off.
Heir. So would their children have to, or cousins and stuff? Or?
No. So if I had a child, I have 3 children. So all 3 children would have to sign off if my things end up in probate. But if one of those children dies before I die, if that child has children, then now their children are involved, and their children have to sign for them. So probate is a process. I know that some people try and do it themselves, but I get an awful lot of people that spent hours and hours and hours and still end up in my office paying me as an attorney to probate. It's 16, 17 pages. Most people don't know which form to fill out.
And often there's a lot of your time is spent undoing the harm that they've done in trying to do it themselves cheaper. And so it ends up costing them more on the back end instead of just doing it right the first time. It does.
And I will also say that you need an attorney that knows what they're doing. I have a client now that is a widow with 2 children. Her husband passed away. She went to a local attorney and he probated the will. But the only thing in the will that was left, because the bank accounts were joint, everything was joint or beneficiary, the only thing left was the real estate.
Yeah.
So, and it was a great deal of real estate, like 15 pieces of property. And the deeds had belonged to grandpa. So the deeds were quite old. And when she finishes probating, then you're sworn in front of the judge, and the judge gives you the paperwork, giving you the authority to then go and do whatever you need to do, whether that's a bank account, whether that's to change a deed.
Okay.
So she goes into the attorney that had charged her and probated the will and says, okay, now transfer the property. And he said, oh no, I can't do that. I don't, that's above my pay grade. So I just happened to be walking past the CPA's office, and the CPA said, hey, come in here and let me ask you some questions. I took this on. We did what, in my opinion, should have been done in the first place, which is a year's support. A spouse can do a year's support within 2 years of the death of the other spouse. And it then will automatically transfer all of the property.
Okay.
And cars and bank accounts, and you get out of paying the property taxes either the year that you file the year support or the next year.
Oh, so that can save you thousands.
It can save you thousands of dollars. And so in this lady's case, I'm sure that it did save her thousands of dollars.
Well, it's thousands of dollars per property. And she had more than 10 properties, 15 properties.
She had multiple properties. And plus then all of the deeds are transferred over into her name, so there's nothing left to do. So, going to an attorney that didn't know how to handle the deeds, she ended up basically having to probate twice.
Right.
And so it was double probate fees, double newspaper fees, because it has to run in the newspaper for 4 weeks to creditors saying, hey, we're probating.
Wow.
Listen, I think it should be easier to die in Georgia, but unless you become governor and change these laws, then we are where we are. And the interesting thing is they're a little different county to county and what each county requires. Mm-hmm. I do probate for the whole state of Georgia. I've got one now down in Vidalia. I've had them all over the state of Georgia. But avoiding probate is what you want to do if you can.
There's other fees involved with probate, and there's ways to word the will correctly to avoid those fees. Can we talk about that? Well,
yes. So that's why a will is so important.
Yeah.
The will needs to state that the executor, the person that's going to be in charge of the will and do the probate and handle selling the property and doing whatever, is exempt from posting a bond, filing an inventory, filing a report, filing a return. If the will doesn't specifically state that, then they have to do all of the above. I've had clients.
And those things aren't free, right?
They are not free. I had a client that had to, out of their pocket, spend $500 to post a bond. Then they had to post it. I've got one now where the gentleman hand wrote his will. It was notarized. It was witnessed, but he didn't excuse anyone from doing that. So she's having to do the inventories, the reports, the returns, and the, I'm helping her with it. So there's attorney fees. The court is charging her for every single form. And it just makes things quite challenging, costly. So,
And those fees that you can get out of if a competent attorney helps you, I mean, that can add up to hundreds, if not thousands, right?
Yes, thousands. It adds up to thousands. And that must be done in the will. That must be a proper will, and that must be taken care of in the will. So
you said the word executor. Tell us, does it matter who is going to be the executor of the will? I know that as your law partner, I'm the executor of your will, but does it matter if the spouse is, or if a kid is, or?
So that's a very good question.
If your lawyer is?
I no longer, because I'm positioning myself to take it a little slower, I no longer accept the responsibility of being an executor. I am on a few wills. But
in my opinion, it would be better that a family member
absolutely
deal with it. Sure.
So having lost my husband almost 3 years ago, I can tell you that I was in no position to be that executor, but you don't have to probate the will anytime soon. You don't have to do it quickly. You can get through that shock and get through that grief before you have to do it. But I have, husband and wives who thinks, well, if I name you executor, it's going to offend the other two kids. It's not a place of honor.
Right. It's a bunch of work that I'm about to hand to one.
It is a bunch of work, but it should be the one that lives closest to you, because I have one that I sent out today. One son lives in Georgia. The other son lives in Texas. So it's going to be much easier for the Georgia son to take care of this and handle this. He's in the same time zone to begin with, even though he's not in the same town. So, and in my opinion, you should always name an executor and an alternate. The situation with this will with the two brothers is mom had a will. She named her husband as executor. He died before she did.
They never updated the will.
And never updated the will and didn't put an alternate executor. So I had to contact the court and say, okay, which form do you want me to use? And they said, we have to use this one. You got to explain it out. Everyone's got to be in agreement. But it would have just been much faster and easier had there been an alternate, one of her sons.
Right.
Now, I have also seen occasions where there were two daughters. One lived in Pennsylvania, one lived in Florida. Mom made them co-executors. And that is never a good idea, in my humble opinion, because you both got to be together. You both have to sign off on everything. You both got to be in court, being sworn in.
Oh, because it's effectively making it a twin sister type situation.
It's a twin sister.
Wow.
So I explained this to the sisters, and the one in Pennsylvania said, oh, I'm too far. I tap out. But then we still had to fill out forms and file those forms with the court, which was additional fees.
You've been named the executor. You don't get to say, I'm not.
That's right. Wow. That's right. It's in the will that they're both executors. So one has to tap out and the other has to agree to that. And you have to fill out forms specifically for that. Also, your will needs to have a self-proving affidavit. I had one in another county that will remain nameless because that county is a nightmare, but there was no self-proving affidavit. And so we had to go and find these witnesses that had signed this will 10 years earlier.
Wow.
And then they had to sign interrogatory saying, oh, yeah, I saw him sign that. It was him. It is his handwriting.
And then get that interrogatory notarized. And this, wow,
yeah, and the interrogatory costs attorney fees. The interrogatory costs court fees. And let's just say, because I have had this happen, we could not find the witnesses. Now we've got to find two people that are not her heirs that can swear that that's her signature on the will. Okay. Yes. They have to say, I know her signature. I'm familiar with her signature. I was her banker or her investment broker or her mechanic. I had seen her signature multiple times. So this is why going to an attorney that knows the law in the state you're in and knows how to do a proper will. And now that I've said in the state you're in, we have a retirement subdivision in our town, and we have people move here from all over the country, and they come into me and say, my will is from Connecticut. Do I need a new will? Absolutely. I always say, do you think you're going to stay here and die here? And if they say, no, our daughter lives in Florida, we may leave there in 5 years, then by all means, do it when you get to Florida. But if you are going to stay here and die here, it needs to be state specific so that it covers everything that state requires.
No one, I won't say no one, but certainly no one likes to plan for their death. No one says, oh, I'm going to die in this many years. But at the same time, you want to be able to have that plan. Hey, what happens if I'm totally healthy? You mentioned earlier when Dad died, he was healthier than I am now.
He was much healthier than I am.
And so it was extremely sudden. But everything had already been taken care of. And I know that was a huge comfort to you, because we're dealing with this tragic loss, this sudden loss. We didn't plan on this loss, but hey, everything's taken care of. So all of that weight that shifted from his shoulders onto yours was already gone, because it had actually shifted on to the will and the plans that he had already left. So
that's why it's so important. And it's not just important to say, all right, let me see what happens if I die tomorrow. What is going to go down? I've got a house, I've got a bank account, I've got an Edward Jones account, I've got this, I've got that. And then you say, and who's going to argue? Right? For me, I've got 3 kids. It would be my 3 kids. Who is going to argue? And I understand.
But nothing, I've seen totally happy families
be ripped apart. Absolutely ripped apart.
But not even necessarily ripped apart. I've seen, but I wanted the piano.
Yeah.
Oh no, but I practice on it the most. And mom didn't say who gets the piano. And so even though half the family thinks, oh, it was settled like it was supposed to, the other parts of the family that didn't get the piano 20 years later are still like, I should have got that piano.
Should have had that.
Whereas if the will says, Susie gets the piano, then like everyone else, Jane doesn't get to say, we don't get the piano.
So I took my kids through my house. I took my girls through my house, and we talked about china and nativity sets and clocks, jewelry, and who wants what and who gets what. And then I put a little tag in each piece and said, hey, this was a bowl that belonged to my mother, and it goes to Kristen.
And we did that with Dad's guns.
Yes.
Me and my brother.
Yeah. And so that kind of thing you can do. But it is very important to think about what is going to pass when I pass away. And again, my husband and I both thought I'm the one with the health issues, that I would go first. He went first.
Yeah.
So, normal wills, if the husband dies, it all goes to the wife. If the wife dies, it all goes to the husband. But then you've got to have, but if that person dies, you also need to play worst case scenario for, financial situations. What if you're dependent on the 2 incomes or the 2 Social Security checks? And
Survivor
one dies.
benefits,
Yes, we've got to figure
pensions.
out what happens if you die and I remain. What happens if I die and you remain? So these are kinds of questions you've got to look at. What is going to pass through the will? What happens to me financially when you die? And who's going to be the people that are beneficiaries? And who's going to be the people that might argue? And how do I prevent that arguing?
Well, our time's up for this episode, but it sounds almost like we need an episode 2 of Alta End of Life Prep. I want to thank everybody today for coming in and tuning into Milltown Lawyers. We've done a lot of this, as you can tell. Debbie is a pro, and I'm obviously very partial. I think my mom is just the best. But if you don't have a will, or you have a will from another state, it is definitely worth your time to come in, have a Georgia attorney look it over, somebody who knows what they're doing, somebody that can deal with all parts of that will, from end of life directives to the deeds to the will itself. It's worth it, even if you don't have to redo it. Have someone take a look at it. You don't want to leave your kids with the question of, well, now what do we do?
And I will say that there are attorneys out there that they call themselves estate attorneys, and they will give you this lovely, big, huge binder. There's one right there. And they will charge you thousands and thousands of dollars for that. And those are not always necessary.
That's right.
My wills are short, concise, 6 pages. They say what they have to say. They take it all in.
None of the fluff that
fluff
makes it seem like, look at all
That's
this work I've done for you.
Look at how good I am. Yeah.
Well, if you want us to take a look at this, if you want to talk it through, you can reach us at DuttonLawGA.com. You can reach out to me for any small business issue at thegeeklawyer.com. Again, staying informed is your first step. Thank you again for tuning into us. Feel free to, this is a video, so you can like and subscribe to us for future updates. Again, thank you for tuning in.
Bye for now.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.